very good afternoon to one and all. I, Chirag Balyan, Center Coordinator, Arbitration Center, National Law University, Mumbai, welcomes you all on this Saturday evening for a webinar on discovering full potential of e-discovery in India's dispute resolution landscape. Today, we have the privilege of having some of the distinguished experts in the field of dispute resolution. We have Mr. Jayesh H, who is the co-founder of Juriscorp. We have Ms. Dipti Gandhi, Senior General Manager and Head Litigation, Mahindra & Mahindra Group. We have Mr. Amit Jaju, Senior Managing Director, FTI Consulting. We have Mr. Mrinal Jain, Managing Director, FTI Consulting. Mr. Kevin Nash, Deputy Registrar and Center Director from Singapore International Arbitration Center. Mr. Shubhabrata Chakraborti, partner at Juriscorp, and myself will be moderating this session. Today, we are going to talk about some of the most important issues which have come up because of the COVID-19. That does not mean these issues were not there. The use of e-discovery was always there. But because of more reliance upon the technology, because of the pandemic, now the requirement of methods like e-discovery has increased. So with this small note and to discuss these issues, Professor Dr. Dilip Ukey, who is also the Vice Chancellor of National Law University, Mumbai, has also joined us, and I welcome him. Sir, we understand you have very short time. Please, you can start with the opening remarks.
Thank you, Mr. Chirag. Very good afternoon to all the esteemed panelists and the dear participants. On behalf of Maharashtra National Law University, Mumbai, I welcome you all in this webinar on potential of e-discovery in India's dispute resolution landscape. As Professor John Rawls, who has famously described justice as the first virtue of social institutions. Goal 16.3 of the Sustainable Development Goals of the United Nations states, to quote, promote the rule of law at the national and international levels and guarantee equal access to justice for all. Today, technology-enabled inventions can play the role in advancing this virtue. The aim of justice should not be treated merely as a tool of dispute resolution, but as a catalyst for social and economic development. Legal technology has the potential to be a game changer in the quest for access to justice. E-discovery is cutting down on the cost of lawyers required to assist on large-scale document review projects. Digital contracts make the whole process more streamlined and cost-effective and enable people to do business anywhere in the world without any delay. These efficiencies can all be passed on to the clients, resulting in the provision of a more affordable and thus, it is hoped, more accessible legal service. Thus, technology-led access to justice initiatives like e-filing, virtual proceedings, complemented with e-discovery can go a long way in making the system more efficient, cost-effective, and transparent. The rise of legal technology has transformed the legal practitioners into data brokers. There is also growth of new hybrid professionals like legal knowledge engineers, legal technologists, and data forensic experts. However, the use of legal technology requires the proper assessment of potential risk and harm, which includes potential of data misuse, data security breaches, and confidentiality breach. Specifically, there are challenges pertaining to technological incompetence with solutions like e-discovery. Further, the use of legal technology must be assessed in the light of the digital divide. The digital divide affects access to ICT, connectivity, digital literacy, and the ability to afford software updates and cyber security protections required for using legal technology effectively and safely. While touted as a tool for legal empowerment, if not implemented carefully, technology can deepen existing inequities in access to information. I hope that today's discussion on the potential of e-discovery in dispute resolution will pave way for the justice which is efficient, accessible, and reliable. Thank you so much, and I wish you all the best for the same.
Thank you so much, sir, for giving an overall overview and the context in which we have to look at the present discourse of e-discovery. With this small note now, I pass on to Shubhabrata Chakraborti to give the introduction and the overview of the webinar.
Thank you, Chirag, and thank you very much, Professor Ukey. So, just to give a brief, a bird's eye view of what we are going to discuss today, and we are fortunate to have such a distinguished panelist with us for discussing all these important issues. So, we all know that one of the essential elements of rule of law lies in its procedure. Discovery is one such tool, one such procedure, which is aimed at facilitating an early and expeditious disposal of a litigation or a particular matter. So what is discovery? In normal parlance, what we understand from discovery is it is a tool by which a party is called upon or at times compelled to produce documents which it has in its possession, and which particular document is relevant for in the context of the matter which is disputed or which is in trial. Now, this discovery, we have found that, or we know for a matter that it is embedded in our statute books for long. It has been put to use also. But with time, things have changed. Technology has become an integral part of our lives. And as such, e-discovery has now taken the center stage. We communicate through emails, WhatsApps. We store data in servers. So hence, discovery has taken a shape of e-discovery, electronic discovery. And with this, today we would discuss few things on e-discovery, more particularly the scope of this discovery, the stages of e-discovery, its relevance more importantly, and of course, the effects of non-compliance should a request of e-discovery is made and this request is not complied with. We'll also discuss the hygiene rules, that is what is meant to be a best housekeeping rules from the litigation hold perspective or otherwise. We'll also discuss the interplay between data protection, confidentiality, and e-discovery. And we'll also understand the perspective of discovery from the eyes of a forensic expert and definitely a quantum expert. So on this note, I would then like to share the stage with Mr. Jayesh, who is the founder and partner of Juriscorp. And I would like him to address a few queries which I'm going to pose to him. So Jayesh, over to you. And I would like to ask you the first query. What is e-discovery? What are the various stages at which e-discovery can be sought? And how it is different from a litigation in a court of law and in arbitration? Thank you.
Thank you, Shubhabrata. And good evening, everybody. Thank you for taking time out on a Saturday evening to join us. Before I address Shubhabrata's queries, it's actually wonderful to have the participants and fellow panelists from all the way from Singapore. Thank you, Kevin, for taking time out on Saturday to join us. Really appreciate that. And Dipti also, having spent a long week, late nights, and still taking time on Saturday. Thank you for that. Before I answer Shubhabrata, I was like really pleasantly surprised at what Dr. Ukey said in his opening remarks. I thought I'm the sort of the lone voice out here who keeps talking of technology in practice of law and in the context of litigation, and to have Dr. Ukey talk about lawyers as data brokers and legal technologists. It's so really delightful. MNLU is really keeping up the curve with what is happening in the world from a education perspective. So I think soon we will have lawyers who may do sort of cross over the bridge between information technology and legal specialists, so to speak. So with that, to address Shubhabrata's point, and as you pointed out about discovery, and that misconception I wanted to clear first before I get to the real point. And many people think, oh, discovery only happens at trial, and discovery is about physical documents only. Now, there is not much of a difference in the concept of discovery and e-discovery, except for the meaning. Discovery is in the physical world, documents, files, maps, notes, or whatever you want to call them. E-discovery is anything which is electronically stored information. Of course, that's a paradigm shift out there because the medium has changed, but the principles of law and the way it can be used remain the same. And that's what we sometimes tend to forget, that we think that e-discovery is sort of a new concept or a new kid on the block, and the law doesn't provide for that as a result because Indian laws take time to catch up with the change in technology in the commercial world. That's not true. The provisions which are there for discovery do adequate justice, and in fact, way back in 1999 when we enacted the Information Technology Act, certain amendments were specifically made to the Indian Evidence Act to ensure that there is no doubt that the reference to evidence or documents, for that matter, includes electronic evidence and electronic documents. So I don't know, Shubh, does that answer your question, or you really want me to build upon this further?
So Jayesh, that answers my question. But if you can discuss about the various stages at which discovery can be sought, because that is a very important part.
Oh yes, of course. Now here's the fun thing. If you were to ask lawyers, most of them say, of course, discovery is something which you can ask before the trial and so on. And yes, in many cases, that's what it ends up happening. But if you ask me, the law doesn't stop you from even wanting discovery to be done when you have filed a plaint and have filed an interim application seeking some injunction. And there are case laws to support this, because what matters to the court is what is being asked for. Is it relevant to the stage at which the proceedings are? I mean, there are other factors whether to allow discovery or not. But the one key aspect is it relevant to the stage at which the proceedings are? Now, if you're seeking injunction and you are saying that the other side has some documents which will either further your case or demolish their defense as to why injunction should not be granted, etc., then you are very much within your rights to ask for that documents, discovery to be done, and get it produced so that your injunction can be disposed of in a fair manner. Now, again, the point which Dr. Ukey made, and even you and Chirag mentioned, is about efficacy and the rule of law. Now, if you look at it, actually discovery goes, and e-discovery therefore all the more goes a long way in having efficacious justice being done. And see, as plaintiffs or defendants, you only think of it from how does it work for us. But when you look at from the legal system's perspective, it is all about fair trial, justice being done in a timely manner, and balancing the interests of the parties. E-discovery really plays a major role in ensuring that happens. Now, therefore, at what stage can it be done? I think in the litigation context, of course, you can't ask for discovery before you've actually filed your case, a plaint, so to speak. There may be exceptional cases where you may claim that I have a contractual right for information and therefore I'm seeking enforcement, but that itself requires you to file a plaint and so on. In the arbitration context, as a concept, and I'll ask Kevin to answer this also. Of course, you could ask for it before having filed a statement of claim. At the preliminary hearing, you could move an application. But I would be surprised if the arbitrators were to allow it, because it's like you want to pitch your case, your statement of claim, depending on what documents the other side turns up with. Whereas normally it is something which you will do after the initial set of pleadings have been filed, before the issues get framed, so that the very aspect which is going to be really contentious can be reduced, can be narrowed down by what turns up in the discovery process or the e-discovery process. At times, but not so often, you may even ask for e-discovery after issues are framed, but you really have a higher threshold to surmount to demonstrate as to why you couldn't have asked for it earlier. Therefore, it's either something has turned up to your knowledge now, and with all the diligence in the world possible, you couldn't have got that knowledge earlier, or something which the other side has conducted or led now after the issues were being framed and so on, has made you aware that there exists something out there, the so-called smoking gun, which could either demolish their case or make it redundant for you to prove your case and so on.
So Jayesh, so if there is a new development that has taken place during the course of the trial, are you suggesting that can that be a reason to seek discovery?
But, yeah, well, yes, but the new development has to be a factual material new development and not like, oh, I now I remember, my former colleague was also working on this matter and we should have asked for exchange of emails between him and the other side's CFO, so to speak. I mean, that is not a new development. That's something
Understood.
because you did not, think through earlier on at the right time when you're seeking e-discovery or discovery for that matter, what all correspondence should be sought to be put on record.
Understood. So on this note, I would like Dipti to give her views on the relevance perspective or the relevance part of e-discovery. My question to you, Dipti, is what's your view of e-discovery in dispute resolution process from the corporate perspective?
Well, I think it's the most important development that must take place in India. So far as the litigation and the arbitration perspective is concerned. But before that, let me wish everybody a very good evening and thank you all the participants and good evening everybody. Having said that, yes, it's one of the most relevant things for litigation and arbitration from the perspective of time and efficiency and cost. Because so far as litigation is concerned, especially in India, the amount of time that litigation takes, and by the time the litigation does come to its finality, and from the time it has been filed to the time it comes in its finality, there are so many people in the middle from a business perspective, including the legal teams who have
Correct.
changed. And because of that, what began 20 years back with a suit being filed to the issues being framed 20 years later and the documents being produced 20 years later, there have been enough experiences to know that um, in huge corporates or even in small companies, the document preservation is one of the difficult and the most most irregular thing so far. So at that point of time, 20 years back, it may have been safe and secure, but 20 years later, it's always an extremely difficult task to get the right original documents in hand, etc. Secondly, with the advent of technology and with all the communication like emails, etc., being accepted as a mode of evidence, it also becomes extremely important because as we know, like, when we had the camera roll and we could click only 32 pictures and now emails, so there was a restriction on the number of letters, things that get exchanged between businesses, between lawyers, etc. You send things by RPAD. Everything it takes time and therefore there's not so much of data. Now with the advent of WhatsApp, messages, email communication, etc., there's unlimited data to store and unlimited data to produce by way of evidence if the parties so do want to rely. And if we had to resort to physical discovery, it's too cumbersome and time consuming. And we aren't even sure whether we would be able to put up everything together. So I think from a litigation and arbitration perspective, the faster the corporates as well as all the other private companies or parties per se make document storage and retention a priority, and they're such a manner that when e-discovery is accepted form in India with a proper act and rules and notifications, uh, it would become much easier for the legal teams of the corporate and the business teams and everybody else to fight a case on a very just and equitable level.
Understood. Thank you very much for this, Dipti, and I will discuss about the best housekeeping practices later on. But I would like to now move on to Amit and ask him a very pointed question, that is regarding the relevancy and the reliability of the evidence that is produced through the e-discovery process. So Amit, can you answer that?
Sure. Thanks, Shubh, and good evening, everybody. Having spent over 15 years in digital forensics and e-discovery, I have seen that electronic evidence has become more and more focal to any investigation and dispute these days, and other panelists have touched upon that. So in today's world, all our communications are digital. Contracts are stored electronically. Not just unstructured data like documents, emails, and contracts. Even transactions are important to any dispute and investigations. I'm talking about financial transactions, ERP records, and also intellectual property and behavior data of specific custodian and users is also electronic. So it's not just what document they worked on, but what were they doing, at that point in time, especially in financial fraud. That's important. Also, it has become both easy and complicated in today's world because everything is electronic. E-discovery as a feature is built into a lot of platforms. So if all of you use Office 365 as email, e-discovery or preservation and hold is a click of a button that you can do on certain custodians, which was very difficult a few years ago. But information is scattered across. So, as you rightly asked, the reliability and relevancy of information is very critical because there are so many data sources. Finding the right data source is important, and also ensuring that the collection and preservation is done in a forensically sound manner so that nobody can question the authenticity, the integrity, and the reliability of that information. One more important point here is to note is that independence. So many times, when there is an internal inquiry, then it's fine. A corporate can follow internal procedures which are already defined. But when it's a dispute or a investigation involving external parties as well, I think the independence of the full process is very important, and I have seen in many cases that gets questioned. If part of the data collection and preservation is done by in-house teams and then somebody external just hosts that data, then there is a question on the integrity, which, when you ask the internal teams, say a technology team of a corporate, then it's not the best position to be in. So the whole process has to be independently either supervised or done. And the forensic technology side or the digital forensic side of identifying where the data is, how are you collecting that data is very important because, for instance, from an integrity standpoint, calculating hash values of that data is important. Now we are talking of mobile devices, cloud storage, cloud servers, transactions, social media, that all have to be collected, preserved, and produced in a manner which is forensically sound and can be reviewed efficiently also. So this is where I think e-discovery plays a crucial role, where one, it stamps trust on the information produced. So one thing is you eliminate the human element, you use the best of technologies and automation so that nobody can go in and tamper anything while it is getting collected. Also collecting data from multiple sources so that you can corroborate and see if a user's desktop or laptop had X number of emails, the server or the message store or the backup server for emails has X many emails. So you can corroborate and see, okay, he deleted certain emails locally, but the server has X number of emails. So we are able to produce the full population of what emails were there. Second, e-discovery also plays a very important role in making the entire review process efficient. So one point is producing and collecting information which is relevant and not tampered with. Second is how effectively can you review that also. But if you produce 10 million documents with 2 days left to produce those, it's not possible. Even if that information is all relevant, you cannot do justice to that information. So using advanced technologies such as machine learning and AI, which is used very regularly now, even on Indian matters on e-discovery, using technology-assisted review or TAR, which we also use very regularly on Indian matters, you can reduce the time and make the search more efficient. So I think these are two factors which also contribute towards the relevancy and the reliability of the information that is produced from e-discovery. Does that answer your question, Shubh?
It does. I think, Jayesh, would you like to add something on this?
Yeah, in fact, building on what Amit said, just 2 points. He's talked about hash value calculations and why that is important. How do I demonstrate that an electronic document or electronically stored information I'm producing is actually the real thing and not being tampered, etc. That's where what Amit mentioned comes in handy, hash value calculation. There are other such technical factors which Amit will know better, but I'm giving you the legal perspective. It's like calling in a handwriting expert who says, oh, yes, I confirm this check was indeed signed by Mr. So whose other handwriting I've examined and I've done the analysis and all of that. Imagine that now artificial intelligence doing it for you. That's one. The other point is from an integrity perspective again. At times I forward emails, but I delete stuff from the original email because it's something sensitive which the people who are sending it to don't need to know about it. How will you come to know that now? Tomorrow, otherwise, the email which I forwarded will be treated as a genuine email, the email which came in. Again, the way e-discovery works and the technology which is behind it and which Amit is very familiar with, enables to nail it down. If tomorrow I were to claim, oh, this is the email I've got and this is what I sent to Shubhabrata, Amit will be able to put out, no, but Jayesh, you know what? The records, the meta tags and the hash values show that the email has been modified. And the original email had some other content, not just question of the difference in the byte size or whatever, and there are other parameters. So there's a complete, as I used the word paradigm shift earlier, to prove that whether this is the real thing or has been modified for deliberately or unwittingly is a different issue. That becomes so much easier when you start operating using e-discovery softwares and technology.
So I'd like to just add to Jayesh's point, just a very quick example which audience can also relate to, that, a lot of these phishing attacks are happening these days where finance professionals and executives receive this email from a vendor with the correct invoices and PO to make payments. Most of the times hackers tamper the bank account information from the invoices and the payment goes into a fraudulent account. Now, yes, these attacks do exist, but in many cases, if you're not looking at the right headers, the hash values of the emails, tracking them, you would miss out that in some cases we have discovered that employees themselves did it, posing it to be a phishing attack. So these not trusting information is very important. As it is presented, you have to question that, and that is crucial before the discovery process starts.
Okay, so taking this forward, Jayesh, I would like to ask you, what is the scope of discovery then? Means, taking this as an example, what Amit just elaborated or enumerated. And I would also like to ask that I'm given to understand that e-discovery is not allowed as a phishing or a roving inquiry. So can you give some heads up on that and explain us?
So, scope and fishing and roving in a way go hand in hand. So while on one hand, let's put it this way, if you and I have a dispute and you deny whatever I've claimed now, but I believe there's a document lying with you which is contradicting what you're now saying, right? I'm entitled to ask for it. But does it mean I can ask for, oh, please share, all the correspondence exchange between Jayesh and Shubhabrata for the last 5 years? I think any court and any sensible arbitral timeline will just throw that request out. Because you can't make it so wide and sweeping in phishing inquiry. It has to be, okay, any communication exchange between Jayesh and Shubhabrata relating to today's MNLU webinar, for example. I'm just throwing a random example. Because you have to not like completely precision to the nth degree, but some parameters have to be set in which will make it easier for Shubhabrata to then run a process on his own, be it a laptop, be it his mobile devices or iPad or whatever else Shubhabrata may be using for electronic communication to pull it out. Because if it is kept wide, the courts will often throw it out for the simple reason the factors are not only whether it's relevant, but is it also fair to the other side. So I may be trying to be lazy by not wanting to ask exactly what I want, and maybe also hoping that in the process of asking for this very wide approach, I may get something else. Whereas you will protest that, asking for something like this so wide will cost you so much and the amount of time which has to be spent and all of that. And it's not commensurate to what is being asked for. So that's why the coach will end up, balancing the process as to, that is one part. Now, second, and this is, sort of a warning, to be also taken. People assume that only the office laptop or computer can be, used for e-discovery. That's not true. So your personal mobile phones, digital gadgets, anything else which you use, if it can be demonstrated that you have used them in the work context or in the context of the issue at hand, in any manner, then the data lying on that, anything electronically stored information which has been created or stored or generated through that device, can also be then sought to be made the subject of e-discovery. Now, especially in the context of some of the regulatory inquiries, and even in India, the antitrust authorities, they have succeeded in asking for e-discovery to be done even on these personal digital devices. So when I talk about from the scope perspective, it's not just what all can be asked for. It is also relevant to think about it on what all, in the sense, the devices of the medium can it be asked for. And Dipti made a valid point about the 20-year gap and all of that. That trial, the suit got filed say in 2000, and now the trial is happening. Documents may be scattered, etc. This is where the plus and minus of e-discovery comes in. In the sense that, and we'll come to litigation hold later. But the other point is, in the earlier days, imagine a football field full of cupboards having physical paper, and you having to go through it and make a case out of it. And now you have a software which people like Amit will run that process. They will sit with either the clients or lawyers like us to understand what are the various parameters to apply, what are the phases to look at, and all of that, and then generate documents. When I say generate, it's actually the documents already there. Pull out those documents which are then relevant and narrow it down accordingly. So that football full of, stadium full of cupboards with papers may become like a small room full of now cupboard full of papers, and then further deep diving into that, you will start reducing it further. So that's how the process works. From a scope perspective, the other interesting thing to keep in mind is, Shubh may claim this is a privileged communication. Now there are two parts to this. If he claims it's a privileged communication, he may be able to not have it become the subject matter of discovery. But if he claims that for other reasons it is inadmissible in evidence, that is not relevant from a discovery process. The courts have been clear that admissibility in evidence has to be seen at a later stage when it's actually going to be used in evidence. Right now, the production of the document, the only defense you can really have is whether it's a privileged communication.
Understood. So, thank you very much, Jayesh. Kevin, can you explain how SIAC reacts to these kind of situations, these kind of requests for e-discovery? What is the standard SIAC maintains, and are there cases of non-compliances of an order of e-discovery, and what are the consequences of that?
Yes, sure. Thank you, and thank you to the organizers for putting together this session. What I'll try to do is outline the framework under Singapore law and the SIIC rules, and really look at this through that lens as well as international best practices. I had a couple immediate reactions from Jayesh's intervention. First of all, I can remember very early in my legal career those football fields of documents. If you look at e-discovery and electronic documents, there is a possibility of streamlining the process done properly. So I think it's important to remember that there are risks with perhaps too much disclosure, but there's also a potential to streamline things. So the position in Singapore is that under the Singapore International Arbitration Act, the tribunal has the power to order discovery of documents. So Singapore law does not prescribe the type of documents that a party must disclose, and the scope is in the discretion of the tribunal. While not mandatory, it's fairly common practice, particularly in SIIC arbitrations, for the tribunal to refer to the IBA rules on the taking of evidence or any other disclosure rules that the parties may agree. So the parties may choose to adopt this in full, adopt it in part, or use a different type of disclosure regime. Under the IBA rules, similar to the SIIC rules, parties must produce documents that are relevant to the case and material to its outcome. So if the parties agree to conduct an arbitration in accordance with the SIIC rules, or really any institution, procedural rules of the institution will apply to the extent it's not inconsistent with the Singapore International Arbitration Act. This is for a Singapore-seated arbitration. Naturally at SIIC, particularly with Indian parties, we have a variety of seats, different laws governing the contract, so you can really afford a lot of flexibility. So the parties then supplement the laws of the seat, the chosen procedural rules, let's say the SIIC rules in this situation, and then perhaps guidelines such as the IBA rules on the taking of evidence. The SIIC rules provide that the tribunal has the power to order any party to produce to the tribunal and to the other parties for inspection, and to supply copies of any document in their possession or control which the tribunal considers relevant to the case and material to its outcome. So how does this normally work? And with discovery or e-discovery, the process is pretty much the same. Tribunals and SIC arbitrations will often use a Redfern schedule, which, as we all know, is a collaborative document which tries to facilitate the discovery process and sets out a description of the document being requested, requesting parties' justification for the request, any reasons for refusing the request, and then the tribunal's decision on the request. So how does this work? First, the party will produce the documents which it relies upon or intends to rely upon in the assistance of its case. Then the party seeking documents from the other side will submit a request to produce. Part of this request will typically include an explanation as to how the documents requested are relevant to the case material to its outcome. It can be for specific documents or a narrow and specific category of documents. This is important. If the other party objects and refuses to produce any of the documents or the class of document, the tribunal at the request of either party will then rule on this. Some of the objections that we will see is lack of sufficient relevance or materiality, legal impediment or privilege, unreasonable burden to produce the requested evidence, loss or destruction of the document, grounds of commercial or technical confidentiality. And then what the tribunal really needs to have in mind, considerations of procedural economy, proportionality, fairness, or equality of the parties. So with that long winding road to the answer to the question on how a tribunal deals with a party refusing to produce, if a party does not comply with the tribunal's order for discovery, the remedies available are the tribunal may draw an adverse inference. There could be cost consequences. This is one important thing to remember about arbitration, is that it may be that the losing party has to bear all of the costs of the winning party, including if there is a fishing expedition on discovery or a lack of good faith during the discovery process, and then potentially resort to the Singapore court in support of this request and the refusal to produce.
Understood. Thank you very much, Kevin. This was very informative. So, just asking Mrinal now, as a quantum expert, have you faced issues regarding non-compliance, or how e-discovery has helped you in computing damages?
Sure, and thank you all the panelists and audience for patiently listening to all of us and attending this webinar. I'm sure all litigation and arbitration practitioners would agree that it's a general rule of thumb, more the underlying evidence and documentation to support any claim, the lower is the possibility that the tribunal will reject the claim. So in other words, the credibility and reasonableness of any claim or its quantum is dependent on the availability of relevant documents that could be relied upon to substantiate the quantum of that claim. Now, whenever we calculate damages, presence of contemporaneous documents at the time of entering, say, a contract provides a good starting point to calculate that particular damage or claim. So when I say contemporaneous documents, it could be several invoices or ledgers, accounting records, email correspondences, contracts, board minutes, parties approved, business plans, and the like. So more often than not in disputes related to long-term concession agreements, such documents could go back several years, and keeping a track of such documents could be a major challenge, whether in the physical form or in the form or in an electronic form. Now, this discovery process actually enables parties to provide each other relevant information and records, along with all other evidence that is related to the case that is required for the purpose of calculating damages, claims, or losses. Now, this process, of course, can be costly, could be very time-consuming, and I'm sure that some of my panelists here would be covering the cost-benefit analysis. But to be honest, as a damages expert, what we are concerned with is availability of relevant data for a particular head of claim that we are instructed by the councils to quantify. So let me take an example, especially of the termination of a contract. It was an international arbitration, and the respondent actually produced what it has deemed to be all the files from its possession. However, the list of documents is less than the claimant anticipated, and some documents that the claimant knows existed are not provided. For example, in case of wasted cost, and in this particular case, we were appointed to quantify claims related to reliance damages or wasted cost. One needs to review and verify all the historical documents to substantiate that the monies were incurred in the past in pursuing a particular opportunity. And generally, there are two levels of documentation that we need. First is we need to establish proof of liability for the claimant, which could be in the form of invoices, accounting records, and second, the proof of payment in the form of bank statements and payment slips. Now, there could be several reasons, as Kevin mentioned, why the claimant is not in the possession of the documents. Some of the reasons that I found in real life arbitration cases could be the server has deleted the documents due to some server policy, or the physical documents were lost in transit, or the documents are lost in flood. Therefore, the claimant would ideally demand discovery or e-discovery of potential relevant information, again, that may or may not be electronically stored information, which the claimant believes that the respondent has, but are not produced in the proceedings earlier. Now, from here on, it could take two possible scenarios. One, the respondent may agree to provide all additional data as requested by the claimant through the discovery process. And usually we've observed that once the tribunal has instructed the counterparty to provide all additional data, they usually cooperate and they do not decline the request anyways. However, there are situations, and in this particular situation, the respondent continued to mention and stipulate that they have provided all the information that was relevant and there's no other document. Now, in that scenario, the claimant actually may demand to inspect all repositories of the respondent, thinking or assuming that it may have deleted certain ESI. And in this extreme situation of non-compliance, of course, the respondent would argue that there is no relevant information was deleted, all of the responsive files were produced, and that an inspection would expose privileged and confidential information, as was touched upon by Jayesh earlier. But in this particular case, a simple termination of contract dispute actually turned into a full-blown e-discovery battle. And it was difficult for the tribunal, for both the parties and the councils to manage this situation, because everything boiled down to the fact that there was no data relevant to calculate damages. So this is a classic example of non-compliance that I came across.
Understood. Thank you, Mrinal. Thank you very much. So with this, I would now ask my co-moderator Chirag to ask Kevin and Jayesh regarding the legal position surrounding e-discovery and what are the international best practices insofar as e-discovery is concerned. So over to you, Chirag.
Thank you, Shub. So Kevin, I would like to take it forward from where you finished. You told about the legal position in Singapore. Now, we know that discovery can be ordered by the arbitrator or by the court. But when we talk about e-discovery, especially in the context of, say, virtual arbitration during the pandemic time, so can we say that there is a duty to preserve data digitally? And if a corporate do not preserve the data digitally, that may bring all the consequences, what you said regarding cost, adverse influence, or will it be just exposing the digital divide in that context?
That's a great question. I think what a tribunal and parties need to do, particularly in the context of e-discovery, is confer at the earliest opportunity regarding the preservation and disclosure of electronic information, and to agree on the scope and methods of production. This will be particularly important if you have a document-heavy arbitration, a multi-party, multi-jurisdictional dispute. You could have parties from different legal traditions. You could have a US party where there is, of course, more robust discovery, and then a party from a legal tradition where discovery is not the norm. So this is what we're seeing tribunals doing, is being more alive to this and dealing with it earlier. And then particularly if the tribunals or the parties are not particularly tech savvy, even though all the documents at issue are stored electronically, and this is what we're seeing from more and more corporates, is that sometimes upwards of 90% of the documents will be stored electronically. We also see in SIC arbitrations sometimes high-value arbitrations where a lot of the relevant evidence is on, it could be on a chat system. This was referred to earlier. It could be a personal conversation discussing the contract at issue. So conferring at the earliest opportunity is important. I think identifying the types of computer and storage systems, the media data retention policies, all of this that's required for preservation, identifying relevant tools and techniques that can reduce the burden and cost of production, making arrangements with regard to privacy and privilege issues, and then considering whether the parties of the tribunal may benefit from professional guidance on these IT issues if the parties in the tribunal are not familiar with the production of electronic documents. I suppose that is the best practice that we're seeing in SIC arbitrations, but the overall takeaway from that is dealing with it early.
A follow-up question to this, Kevin. Can it fall? So if a tribunal specifically orders for the e-discovery because of, say, circumstances like COVID, physical production of documents is not possible, can party claim a ground of unreasonable burden and say that we can't produce a document?
Yeah, and I mean, I think that a party might absolutely make that argument that this is an unreasonable burden to produce the requested evidence. We don't have access. We'd have to go through all of our systems. We haven't been preserving. So that is an objection that you would see, and that certainly we have seen.
Thank you. Thank you, Kevin. Jayesh, I would like to come to you now with respect to the Indian legal position. Now, the term discovery, we do not hear so much as far as India is concerned. Most of the Indian laws talks about production of documents. Can you explain a little bit to us about the legal position in India and especially the judicial attitude toward the e-discovery?
Yes. Thank you, Professor Chirag, and I'm remiss in not having wished you Happy Teachers' Day. It's people like you and Dr. Ukey and countless others, teachers and professors, who have made us professionals what we are today. So once again, thank you so much and wish you a very happy Teachers' Day. To answer your question, as I said in the beginning, the Indian law very much envisaged discovery. Of course, when it was framed and when the way it got applied, it was always about physical documents. But thankfully, when the Information Technology Act was enacted 20 years back, in fact, 21 years now, they did have the sense to amend the Evidence Act to bring in evidence includes electronic evidence, documents includes electronic documents. However, at that point of time, nobody really had thought of e-discovery, at least in India. If you look at it, and Kevin would know this, that in US and UK or Europe for the matter, e-discovery had started more than 2 decades back. You even have a sort of a global convention on it called Sedona Convention, which lays down the principles and the jurisprudence and whatnot as to how e-discovery should be done and when it be allowed and all of that. But coming back to the law and the courts, there are quite a few judgments, and surprisingly, some of the judgments actually involve the various regulatory authorities like the Enforcement Directorate and so on, statutory authorities, and whether tape recording on a CD is admissible as evidence or not, and so on. Yes, I haven't seen a case law which relates to emails, etc., or documents, agreements, electronic version, and their issue about them being brought in evidence or not. But as we said earlier, e-discovery applies to any electronically stored information. It could even be voice messages or recordings of telephone conversations and so on. So the concept is already there under the Indian jurisprudence. The building blocks are already there. And interestingly, there are a couple of instances where, and one of them involves again a government entity, which oil-related arbitration, where the arbitrators awarded discovery and the counterparty moved the court in India saying that this can't be allowed and excessive and all of that. There on technicality, the court said we can't entertain you because there is no appeal from an arbitral tribunal's order allowing discovery. But there is a different case where when the court itself allowed discovery and it was sort of be challenged, there the appeal was heard, but the appellate court held down that what the lower court had done was right. The ordering discovery in the manner it was to be done. They didn't say anything wrong in it. And the principles got reiterated that basically it should be relevant, appropriate to the stage at which the proceedings is. It will either reduce cost or dispose of the issue, in a quicker manner, and so on. So in fact, those who are inclined technically, it is basically, if I'm not mistaken, yeah, Order 11, Rule 6 and 12 of the Code for Civil Procedure in India, which deals with this. So that's the technical part of it. I'm consciously not citing any case laws, but yes, there are many case laws on this even in India, which are really relevant. Yeah. So, sorry, just one other point I would like to add and to build upon what Kevin said and what you asked, Kevin, which is parties are required to produce documents. I mean, in arbitration, you dare not produce documents if it turns out later on you had it with you, because arbitral tribunals are quick to do one of two things or both the things, which is A, keep this in mind when they're determining whether the cost should be awarded against you or not. And if it is brought to their notice or they're reminded that, look, you chose not to produce documents which are relevant, even though asked to do so, the probability of cost being awarded against you is very high. B, in extreme cases, the tribunal will even throw out your defense, so to speak, etc. Now, Indian courts, while it can do the same thing, you know very well that in India, courts never really award anything close to realistic cost. So that deterrent is not there. But yes, there have been some instances where the courts have refused or, said the adverse inference must be drawn because the party chose not to produce the documents. Then it has to presume that if that document was produced, it would be fatal to that party's case. And that's why it is choosing not to produce a document. So that is sort of the legal deterrent built in. Unfortunately, it is so often left to the discretion of the judges, and that is where we've not seen enough deterrence getting built up and enough jurisprudence getting built up on this front.
So, as I see it, we have arbitration, where we have an opportunity for the case management conference where the parties can sit together with the tribunal and can decide the specific mode of discovery. As Kevin said, through reference schedule, they can decide their mutual obligations, they can put it down on the paper, etc. But as far as courts are concerned, these best practices do not exist. And with this respect, I would like to take you back when you said that admissibility is decided at a later stage. And you said that one of the exception is confidentiality or the privilege. But what about those cases where the prejudicial value of the evidence is far higher than the relevancy? At what stage legally such kind of issues should be decided?
Okay, so let's assume Shubh and Mia entered into a contract and there was some amendments made to it, etc. Now I'm asking for discovery against Shubh and Shubh denies it. And one of the defenses he makes is that, this document would not be admissible in evidence. And his ground could be, oh, by the way, because it was never stamped. So the fact that the document is not stamped, of course, makes it inadmissible in evidence unless certain things are taken care of. But that doesn't mean I can't ask for that document to be produced and use it in other manners if I want to, for example. So I may not be then when it comes to the stage of leading evidence, I can't use that document per se because it's not been stamped unless I've made good that, rectified as per the law of the land, which is maybe pay 10 times the penalty and pay the stamp duty and all of that. But even if I don't do any of that, the fact that that supplement document existed and it contains certain things, whatever it is narrated there, I can use that narration to demonstrate something else there. So that's one. Secondly, because of what is narrated in there, then I'm able, if I have a third document, which otherwise doesn't make sense without the supplemental document, then the third document now can be presented in a manner that is making sense, even though the supplemental agreement, I can't present it as evidence. So that's the differential between whether admissible in evidence or not, and still whether it can be otherwise made the subject matter of discovery. Now, let's not confuse the issue with legal privilege. If Shubh claims that, okay, the document which I'm asking for is correspondence between him and his legal advisors, then yes, it need not be produced in discovery, but that of course it has to be certified as such. And if I believe, and this is where it can get tricky, one classic case law which I allow to quote here, is AkzoNobel and antitrust authorities. They did a dawn raid on AkzoNobel. And then AkzoNobel said what some of the documents seized cannot be taken away or cannot be used because it is subject to privileged communication. There, bizarrely as it may sound in the Indian context, the European Court of Justice said that just because the documents amount to correspondence with the in-house legal team does not mean they're subject to legal privilege, even though there is such a legal privilege in UK, but in many of the mainland Europe, the legal privilege does not extend to correspondence with the in-house legal team. If the same correspondence was exchanged with the external counsel, it's a different matter. So this is the nuances I'm talking about from a context of we will worry about whether it's admissible in evidence or not at a later stage when that stage comes. But right now, is it relevant or not, etc., the criteria which I laid down earlier, that is the basis on which the court will ask for, or the tribunal will order it.
Thank you, Jayesh. So now I would like to move on to next issue, which is hygiene rules. How this data should be maintained so that there is a trust, there is an element of reliability, and when the court is assessing that piece of evidence, there is also higher reliability of that piece of document which has been sourced through e-discovery. Jayesh, again, my question to you is, what are some of the good housekeeping practices for document retentions so that, for the corporates in India?
In fact, Dipti rightly touched upon this in the earlier in the session, that one of the challenges is that the lack of a process and a strategy, so to speak, to maintain documents. And as Amit rightly mentioned, that if you're using Office 365, half the problem is taken care of, because anyway, exchange of emails, they're getting stored. And today's world, most of the documents, agreements, etc., are by attachment to the emails, etc. So again, they get stored. But that's not a foolproof strategy. So you do get, what we call document management systems. And of course, it's not like you buy it off the shelf and just implement it, and Dipti will vouch for this as to how her IT team goes about, implementing certain strategies. It has to be tailor-made to each organization's their approach, etc. But most organizations have something called, routine deletion of documents or emails after a period of time, etc. Unless you have archived it or marked it as to be retained and so on. Now, that is what I think Mrinal mentioned earlier about, routine deletion of documents, or maybe Amit mentioned it. Now, but this is where the balancing has to be done. That if you are deleting documents on an automated basis, no adverse inference can be drawn unless you are required to put the documents in a litigation hold and you did not. But if you have gone around manually deleting documents because your a mailbox is full or whatever else, that still runs a risk of adverse inference. So our experience and a corporate like Mahindra, maybe the exception is that most corporates in India are still not implementing robust strategies when it comes to document management and retention. And according to us, this has to involve both the legal teams and the IT teams, and not something to be implemented in isolation.
Thank you, Jayesh. So I have a follow-up question on this, whether it can constitute spoliation of evidence, randomly deleting.
Kevin, what is your experience? How would tribunals react to that? If the party has randomly deleted emails?
I think there would need to be pretty good justification for random deletion, particularly with relevant correspondence.
Chirag, does that answer that question? Professor Chirag, you're there?
I think we lost Chirag. I think he will reconnect. But I think that did answer Chirag's query. But moving forward, I would ask Dipti that in Mahindra and Mahindra, again from the corporate perspective, what you consider as the best housekeeping practice when you are expecting a litigation or even in ordinary course of business?
Mahindra as a corporate has moved forward to a very large extent as far as document preservation is concerned. So from a litigation perspective, we have a litigation software called the Litigation Management System, wherein all our cases, including all the documents relating to those cases, are all being preserved on the software, which is on iCloud. We also have a document management system wherein our corporate lawyers who work on transactions and agreements and negotiations and the final documents, they are all, um, again, stored on a software. The third system that we have, and which has been recently introduced, is what we call the contract management system, wherein we have involved the businesses now, wherein earlier on documents were getting executed at different places, considering the wide and breadth of Mahindra's, including the number of products it sells and the businesses it has. Every business, every product that they sold, every team had their own operational processes on preservation, signature of documents, execution, stamping, etc. So the legal team has kind of educated business on the requirements of maintaining a systematic contract management system wherein contracts at the senior level, from level A to level Z at the topmost level, can get approvals only online, and then the execution and the stamping would happen, and those documents are also then preserved. It's a new system which is being introduced within our conglomerate, and it will take shape, and the effect of it and the advantage of it will be gained in a couple of years going from now. We also have, so being very conscious of the fact, the way technology is moving, conscious of the fact on the vastness of our organization and the number of products we sell and the businesses we have, we also now are moving towards what we call the document retention system. So since we have a lot of information and documents and emails and data on different softwares, so we also have an Ipr software portal where our trademarks, registrations, everything is all stored in a particular database. But having said that, I just spoke about 3 or 4 or 5 portals which we have, which currently are working in silos in a perspective of storing the documents that are relevant to them. So as a conglomerate and our general counsel, Mr. Naveen Raju, kind of realizes how important it is to club all of this together, whether there is litigation or whether there is a requirement for utility of all these documents, emails, even including finance, accounts, audits, etc., on one platform. We have formulated a team who is now, getting together and trying to find vendors where we would have a lot of these documents on one platform. It's a huge, huge task. It's a huge responsibility. Loads of man hours are going from the relevant team which has been formed. There's a lot of interaction that happens with the IT teams, with, finding out best practices that are there available within our organization. So we have so many independent public limited companies like Mahindra Finance, Mahindra Holidays, etc. So trying to find out best practices of what people are practicing, whether they have, in-house developed a software already, which can be utilized by us, or do we need to buy it from vendors? Getting a buyout from so many stakeholders. It's like everybody questions you on why do we and why and what for, etc. But when they do realize in their own way the importance, not just when it turns to litigation, but the basic requirements of document preservation, we will be getting the buy-in, just the way we started the litigation management system, the document management system, all of it in the last 5 years, like a project metamorphosis. So before that, we really had a lot of reliance on whatever we had, on our servers, if at all, on our hard drives, if at all, or on, physical files which are stored in places. We earlier relied only on that, but now it's a different thing altogether. And since the data is so vast, and since I earlier said that, now any kind of data is called for, whether it's messages or emails or somebody's laptop or entire. It's important that we have some platforms, and Mahindra is definitely moving way into this technology to see that it's tech savvy. And within the next 5 years, if e-discovery becomes a legalized rule, we might be ready. Um, at least going forward with the data that exists, I don't know about like how much back we can move and how far back we can move for the past data, but 5 years from now or 10 years from now, we as an organization would have a lot of things on those technical platforms to assist with the nuances and the regulatory requirements and wherever required e-discovery as well.
Thank you very much, Dipti. And I must confess that you are the pioneer insofar as best housekeeping practices of document retention is concerned. I must confess this.
Thank you so
Thank
much.
you.
Thank you.
So on this point, Kevin, if I can ask you, there is a question which has been asked by one of the attendees, and I would read the question for you. It is that, can you throw light on how should one react to proving spoliation of evidence? And if you have any real life examples to elaborate on this.
To proving spoliation of evidence?
Yes, yes.
Yeah, I mean, it's a bit difficult for me to answer because to a certain degree, discovery is ultimately the charge of the tribunal. So, I mean, we've seen all sorts of discovery exercises in SIC arbitrations, but I'm not sure that I could identify a precise example or would want to take a position on that in any event. I think overall, you want a tribunal that can marshal the discovery process.
Mm-hmm.
The scope and the extent of the discovery is going to have an enormous impact on the cost of arbitration. So arguments are going to be made on each side. I think this does go back to my point of tribunals conferring with the parties early on how evidence is going to be preserved. If after that time somehow evidence was lost or destroyed or deleted, then the tribunal is going to have to take a view on that. Both sides will argue perhaps the side that lost or destroyed the evidence will indicate a company policy whereby emails or documents were automatically deleted every 30 days, and then the parties can then argue that way.
Okay, thank you very much, Kevin. This was helpful. So moving forward, Amit, I would like to have your insight about the importance of hygiene from the perspective of a forensic expert.
Sure. Thanks, Shub. I think the hygiene factor has two elements. One, the basic factors which remain constant, where we have to ensure the integrity of the data is maintained. And two, and the second aspect, which is fast evolving, there was one pre-COVID era and now post-COVID, where our procedures also had to adopt to, keeping in mind the factors around remote working and remote investigations, whether it is digital collection or forensic collection of information, that how do you maintain and cover the hygiene factor. Also, personal data protection regulation or any data protection regulation also plays a crucial role in governing hygiene, because data deletion is one area where, for instance, a data subject can demand his or her data to be deleted. And then how do you tackle that? And Dipti clearly mentioned that multi-tier approach is very important, where you have multiple systems taking care of documents which are extracted from core storage such as emails and are put separately in a legal document management system or a contract management system that allows you to independently manage hygiene, storage, and production of such documents later. But when it comes to hygiene, the most important thing is collection and preservation. So identifying where we collect data from, what's the process followed, has the integrity of the data been tampered before even you collected the data? So what questions you need to ask to ensure that the data given to you is not tampered with. So for instance, if I'm taking a mobile phone in my custody, whether it's a personal phone or a company provided phone, we have various checks that we do all in an automated fashion, because when it comes to personal phone, you can't really open the phone manually and do witch hunting or check settings, because the custodian might say, hey, I have personal information there, so you shouldn't manually do anything here. So we use automation to validate what WhatsApp messages were deleted by running a script, by going into the database that the application uses, what emails were deleted, was there any mass deletion, was the phone recently restored, how long the phone is being used. So these are some basic checks that you do on the device. When it comes to the laptop, you do similar checks. When was the laptop issues? We can see that from the operating system install date. What's the storage on the email box? So typically nowadays we get 70 to 100 GB, but if the user deletes a lot of emails saying that my storage was running out, that's not a valid point anymore. So again, we run scripts that queries the Microsoft cloud or a Google G Suite cloud to check what emails were deleted without even going to the user mailbox. Just on the background, these logs are maintained, and we query that to check what has been deleted. Once we have ascertained that no specific tampering was done on a specific mailbox, we start collecting that information in a forensically sound manner, whether it is a mailbox, it's a mobile phone, tablet, cloud storage, whether it is a SAP system, whether it is a HR system. So all of that data gets forensically collected, and hash values and integrity is being stamped upon across, all throughout the process. Once that is done, we ensure that the human element is, in that process is limited and later on. So the process has to be as automated as possible. And as you might be aware, the technology standards keep evolving, keep changing. So for instance, Apple recently changed their encryption methodology where you can't really undelete deleted data on a MacBook, which has a solid state drive. So keeping that in mind, you now go into a time machine storage or the corporate vault where you would want to retrieve files that were deleted. You club all of this together and put a final stamp on this data, which has been collected and preserved, make multiple backup copies, and then start processing this information. Now, this processing is also very critical. Here, we work very closely with the counsel and the client to understand what's the objective, what's the nature of the engagement. Is it a financial fraud? Is it an arbitration related to intellectual property? So depending on what we are doing here, the processing standards have to be adopted. And this is where data is opened up. We look at metadata. We are trying to do OCR of scanned documents, use advanced analytics to identify relevant documents to the case, link everything together, and then start producing this information. At times we are asked to also check integrity and certify that certain files have not been tampered with, whether it's an audio recording which was on a mobile phone, whether it's a scanned document which has not been tampered, because planting of certain document and emails is also a problem, which can mislead the arbitration or the investigation. We look at pictures, we look at certain PDF files, who tampered it, when was it last modified, created. So certain automation or analytics help us pinpoint these outliers, which look to be, black swans. So all of that is covered as part of processing, and then eventually we start producing this information on an e-discovery platform, and we ensure that when it's an Indian matter, everything stays in India, nothing is transferred or hosted outside the shore, because then it causes multiple complications which can come up later. And the entire process is monitored and logged. So which counsel and lawyer or paralegal is reviewing the document, what kind of analytics was done, what redaction is important, because redaction also has to be logged and produced with the necessary numbering and highlighting when we take production instructions. So the hygiene factor is very important. Now post-COVID, we are doing a lot of this work remotely. So whatever I said is all happening remotely, whether it is collection of mobile phones physically or whether it is a laptop, it's all being done remotely. So the procedures are different, but again, we have to maintain sufficient level of hygienes. Our clients, corporate clients are adopting similar procedures, which Dipti touched upon, where they have vault systems. So some companies use vaults where email before it hits the user's mailbox is stored on the vault. And these companies provide much cheaper storage for retaining emails for up to 20 years. So it's much cheaper than the mailbox. So if an employee leaves, you can delete the mailbox, but the mailbox stays alive on the vault. You can't really search and find emails like you would do normally on a mailbox, but you can produce such mailboxes and do e-discovery on them when needed at a fraction of the cost. When it comes to documents, again, document storage, which is not on emails. Jayesh did touch upon that most attachments are found on emails, but there are certain documents which may not be on emails. So for that, you have to have cloud-based, which is much cheaper these days. You can't really have big data centers with a lot of storage for thousands of employees. Access is also a problem. So cloud-based protected, private cloud-based storage, which also does hashing. So for instance, if I have one file with me and hundreds of users have the same file, the storage should be done only once, right? That's how Google does it. So attachment which is circulated for hundreds, millions of users, that attachment is not stored multiple times on Google servers. They store it only once, but they link that file to multiple users with different file names because the file content remains the one. So that intelligent way of storing is also, from a cost efficient perspective, provides that comfort around hygiene. So these are some of the factors. I think it's a broad area, but if there's any specific questions later, we can take that up.
Certainly, certainly. Thank you very much, Amit. So I think Amit did touch about the cost perspective or the cost aspect. So Kevin, can you elaborate on whether cost is at times an impediment towards a party seeking discovery or asking for discovery from the other side, because data protection or preservation involves cost. So what is the interplay between cost and discovery from an international perspective?
Right now, this question is more relevant than ever because companies are increasingly cost conscious with regard to arbitration. And this is one of the reasons why so many parties choose SIC, because the idea that it's going to be cost effective, fast, and really quick justice. And if you end up in a long discovery process, this is absolutely going to have an impact on the overall cost of arbitration. We know from the very famous ICC survey that 80% of the cost of arbitration are legal fees. So if you end up in months of discovery, you're going to have a longer and more expensive arbitration. We can also see examples from the courts. I can't talk about examples from SIC where the cost of just the discovery process runs into the many millions. A lot of this is going to depend on the scope of the discovery. I was looking at some of our cases with e-discovery and e-disclosure in particular. So at one end of the spectrum, you could have e-discovery limited to copies of electronically stored information relied upon by each party, presented in privileged or in printed or other usable form, all the way to requests for all relevant non-privileged documents subject only to requirements that the request be reasonable, are not duplicating other requests, and do not cause an undue burden. That's a pretty wide gulf in the potential scope. I've also seen on a concluded case, the sum and dispute around 20,000 Singapore dollars. So a very small case. The parties were making arguments on top of arguments about the disclosure of metadata in relation to a series of very tangentially related documents. So the job of the tribunals to ensure that the relevance and materiality outweigh the costs and burdens of production. And this is particularly important with electronic documents. So a $3 billion USD dispute versus a 20,000 Singaporean dollar dispute, and the overall document heaviness of each arbitration is important. I think at a more macro level, at SIC, we're advantaged to a certain degree, not just because we think that we're appointing very good tribunals that can marshal the proceedings, but also because we're on the fixed fee system. If a tribunal is on an hourly rate, sometimes a tribunal might not control parties, not protect parties from themselves that are going to engage in a very, very long discovery process. If you have the fixed fees of the institution, and particularly the tribunal is going to be doing its best to ensure the expeditious and economical conclusion of the arbitration. Of course, you do have to get buy-in, which sometimes it may seem like I'm making the same points, but that's to make our life easier at the institution. But if tribunals confer with the parties early, the parties in the tribunal are on the same page about the production of documents, that's going to be a lot easier than a bit later in the process where tensions may be heightened and then this discovery process can start to balloon a little bit. So costs of discovery can be quite significant, and it's something that parties and tribunals have to be quite cognizant of.
Thank you very much, Kevin. So Dipti, your views on this from the corporate side?
So far as we are concerned, we've had from an e-discovery perspective, I have not had too much personal experience from Mahindra's. Discovery, yes, especially abroad, where, but then that's actually sending scans of say 14 of our senior management's laptops, abroad, and then taking it to the parties there, as in taking it to the right institute which would look at all those documents, and then the next process is to put in the keywords, and so that part of litigation is something that our company has experienced. But so far as e-discovery is concerned, neither in the time that I have been with Mahindra's or otherwise have I had the opportunity to deal with e-discovery per se. So having said that, from a discovery perspective, yes, we do have documents in place most of the time, but there are difficulties at times, and therefore this entire system, like as I said, the last 5 years cases and the cases of the last 15 years are now all on our systems. So from that perspective, life is much easier. But the pure e-discovery part is not something which I am privy to as a personal experience from Mahindra's perspective.
Thank you very much, Dipti. And that explains my question. I think Chirag has joined. So Chirag, over to you if you have any queries to ask to the panelist.
Thank you, Shub, for covering up. My system crashed, unfortunately. So maybe we can take it to the next subject matter, which is data protection and confidentiality. And our question is to Amit, that how do you ensure, or how do you look as a forensic expert at the issues of data protection and confidentiality? If you can give your views on this.
Thanks, Chirag. I think it's a very important area, especially when we are working on cross-border matters. And even Indian matters, now we have the data protection legislation on the horizon any moment. Confidentiality also is an important factor, and I'll touch upon briefly on how COVID has changed that. But it's a big responsibility on our shoulder as consultants, and also we see our clients being extremely cautious with both data protection and confidentiality, because there are responsibilities. So if it is about third-party data, whether it is related to a specific contract, the terms around data protection are very common these days. So how do you manage, preserve, what do you do with with specific data is important. Also, now employees who are working remotely are using personal devices to access corporate information more than ever. Jayesh did touch upon that, especially use of mobile phones where you have both personal and official data there. That causes a kind of concern there to be resolved. But it is important for both corporates and consultants to understand that before the case is started, understanding the characteristics of data is critical. Now you have to wear different lenses considering what data you're looking at. So if I'm looking at data originated from California, which is in India, then my lens would be different. If I'm looking at personal data of a European national as part of a production or e-discovery matter for a multinational client in India with some European employees involved, then that lens would be different. So identifying personal information, treating that differently is important. Identifying sensitive information, treating that differently is important. Where the data is located. So cross-border movement of data, because everything is connected, becomes easy. But before we push the button, we have to understand the risks and procedures that need to be adopted. So data localization, as we call it in India, in litigation and arbitration, is also very, very important aspects. For instance, I'm right now working on a US sanctions matter for a client, which is a European bank. Now, where we are talking about SWIFT messages, transactions, mailboxes. Now, I just can't transfer everything on one central location and start processing, so that violates various data protection legislation. So we had to create a procedure working with the client on how we deal with the mountain of data, which is in different locations and amount to different, characteristics. It is also important that, as Dipti mentioned, they have a separate system for different contracts. That contract has data protection responsibility on the corporate also, subject to that specific engagement. So how would you implement that? For instance, if there is a dispute with another party and you have to produce data, that data also involves data from another third party you are doing a separate project for instance, IT implementation. If you're an IT services company, then you have to kind of make sure that you have sufficient clauses in the contract that allows you to produce that data because it belongs to another third party. So we also work with the clients to ensure that, the data that we collect, how do we define, characterize that data, and what procedures and controls we put in place, which do not violate any of these challenges. Now, when it comes to confidentiality, there are various aspects to it. I'll just give one example of personal data, for instance. I think personal devices is becoming more and more an issue because they are very important to any arbitration and investigation. But there's always a question of, can we touch a personal phone of an employee? How do we process that? I think the employment contract becomes very critical there. I've seen most large companies having adequate measures which gives them the right to do e-discovery even on personal devices if corporate data or that device is being used to access corporate information. So there are necessary provisions in the employment contract or in the IT policy somewhere where the employee is signing off. Some companies have missed doing that. So when it comes to actually collecting and preserving information from a personal device, focusing on the business or the corporate data, it becomes a big roadblock. So that's one area to be looked at. But I think it's all part of the scoping and planning phase. And once we have the PDPR live in India, I think the most important thing would be that data shouldn't leave the shore. Everything should be within the country, processed, hosted. You should be requiring a lot of advanced technologies and tools in-house or with a consultant who has everything within India, whether it is brain space, advanced analytics, whether it is a relativity discovery platform. The data should be stored and should stay within the country.
Thank you, Amit, for your response. Now let me move from data forensics expert to the quantum experts. And Mrinal, if you can give us a perspective on role of quantum expert in this entire debate on e-discovery.
Sure, Chirag. Thank you, and a very happy Teachers' Day to you. It's important to understand that, as Kevin mentioned earlier, that it's the councils who have to first make a request to the tribunal for any discoveries to be done. Now, where experts come into the picture is that they would assist the councils in preparing an application to the tribunal for requesting discovery of documents from the counterparty. And how experts become very pertinent is, and especially in international arbitrations where the question of quantum of damages or claims is pertinent or is in the heart of the issue of disagreement. This is because it's absolutely pertinent to convince the tribunal the relevance of the information required from the counterparty through the discovery process, and how any absence of that information would affect the dispute resolution process and the calculation of damages. And this actually puts councils in a better position because the request for additional data and discoveries coming from independent experts like ours, rather than councils themselves making that request. So what we do is we prepare a detailed list of information depending on what are the different heads of claims, what information is already available and what is still outstanding, and then prepare a detailed note why that information is required for calculating that head of claim. And I want to give one particular example here of an international arbitration. It was an investor state dispute, government of one of the developing companies, in reference to construction of real estate, different asset classes against a private investor sitting somewhere across the globe. It was important for us on behalf of the investor as the claimant to dig out one particular email from the government where it had approved the business plan which was prepared by the claimant almost like 6 years back. That was a very critical evidence. It was a contemporaneous evidence, and the client was sure that the government had approved this plan on email. However, the client itself did not have the relevant email, and there was no document per se on record that stipulated that approval. Also, in this case, one of the approaches to quantify and value the asset classes was dependent on the data related to the real estate transactions that the government had entered into historically with other investors. And despite repeated requests, the government did not provide that data to us on the transactions and the details of the transactions that they entered with third-party investors. It was quite apparent that the government is in possession of that data, which was not available in public domain because of the lack of transparency issues in some of these developing economies. So what we did was prepared a detailed request for e-discovery, including why we need the details of those transactions, why we need certain email correspondences given or relevant to an assessment period. And initially, the tribunal was reluctant. The counterparty, of course, the government objected heavily. But after looking at our note, they were convinced, and the councils also, of course, played a role in convincing the tribunal that in the absence of this information, there is a possibility that one of the parties could be overcompensated. And that's where I thought that as an expert, there was a critical role that was played by us.
Jayesh, would you like to add to that?
In fact, somebody asked earlier about, if somebody does polish of evidence, what do you do? Now let's take this example and let's assume the counterparty refuses that there is no such approval granted by us. So the claimant has a internal communication where the original recipient of that approval has then informed somebody else, you know what, great news, our plans have been approved. Okay, and that email is around. Now the original email by which approval is granted is not around, but this second email is around. Now that strengthens your hands in insisting on this, and that person has left now. The person who received the approval and sent the internal email has left the organization. When the claimant then before the tribunal or court can strengthen its position by saying, look, there is this internal communication which says approval has been received. So all we are asking now is exchange of communication between the two parties between these dates. We want discovery done on that. I would say in 9 out of 10 cases that request will be granted. Now this is where the interplay between counsel and the experts is critical, because if the experts say, you know what, if that approval can be demonstrated, what we can ask for and justify as damages will be completely at a different realm, otherwise in the absence of that. And that brings to me a totally different point. So far we've been talking of e-discovery as of something you do on the other side. I'll be doing grave injustice if I don't talk about the importance and value of doing e-discovery on your own self. And again, Mrinal will give you multiple instances where, the way they went about quantifying or which approach of quantification to take, etc., turned upon what turned up when the e-discovery was done on the claimant itself or the defendant itself by themselves. So which is like, I'm acting for the claimant. I reach out to Amit and say, Amit, will you come and help us do e-discovery on ourselves? Because I want to know what lies in communication exchange between parties, etc., before I sort of close my claim, so to speak, as to the issues and all of that, and I've tied up my hands. Because I need to know what are my weak points, because there may be some internally damaging communication, or there may be something from the other side which they may try to deny. So then I need to keep the door open, that latitude for myself, and then use it at that appropriate time before the tribunal. Now, all of this can only happen when I have reached out to Amit and asked him to do a discovery on my client, as not just as a preventive measure, but as a measure of strengthening my hands and minimizing tying down my hands. Thank you.
Thank you, Jayesh. Shubh, would you like to take it forward?
Yeah, so I have just one question for Kevin. Kevin, have you come across instances where a party has cited confidentiality as a ground not to entertain the request for e-discovery?
Yeah, certainly you use confidentiality in relation to state processes. That is a common ground that is invoked for sure.
Okay. Okay, I think we are almost time. Thank you very much for this, Kevin. Chirag, over to you. You can sum up the webinar.
Before I sum up, let me take at least one audience question.
Sure.
So there's this question where it is asked, and it's open, like whomsoever want to respond to this question. What measures can be used to reduce the data or documents being reviewed? any specific data reduction techniques? From an Indian perspective, how do you manage costs related to e-discovery, an aspect which is already discussed, given that India is a very price sensitive market? I think we can confine this question to how to reduce the data being reviewed.
Let me give a quick response to that. We are right now, and Shubh is handling this matter. And the email trail which we have is running into 2 years long. And when I asked the client, like almost more than a year back, why are you insisting on the same email trail being maintained, and why can't we just create a new email? Because now it takes time to open on my mobile, at least. Even on the laptop, it takes 40 seconds for the email to open up, because it's running into 2 years of continued exchange. You see, you know what? God forbid tomorrow something goes wrong. You don't have to produce tons of emails, because there is one running trail which is having the whole story on. And there are no, of course, if there's a related issue and we have opened up a separate email chain for that, that's a different matter. But on the main issue, we have this same subject line being maintained. So if I were to sum up, this discipline in the exchange of communication between parties and even internal, subject line being the critical part, then maintaining the email chain sanctity, etc. This can go a long way the amount of data which has to be reviewed. But I'll ask Amit to, and even Mrinal maybe to sort of comment on this, because they have greater experience of how they have managed to truncate the document data to be reviewed.
Sure. So just I can add one instance, I mean, there are multiple instances, but as somebody said, India is a price sensitive market, but it doesn't mean that Indian clients don't demand all the best of technology. Yeah. So we are using predictive modeling, unstructured and structured analytics, where, for instance, if once you run the search terms and filter emails and documents based on dates, then we do structured analytics. What it does is, and Jayesh just briefly touched upon it, is start creating families of emails. So if you have multiple emails, so we try and find the email that contains the entire trail. If not, we create our own family, which contains the entire conversation trail and all attachments. So that becomes one family. And then we do email threading, which is something similar. When you do a WhatsApp chat on mobile phone, you see the entire conversation, right? And not just one email. So that this technique is called email threading. Now we do unstructured machine learning based technology assisted review, where if these are 65,000 documents to be reviewed, you would, if you do manual review of that, you need so many reviewers who would review 150 to 200 documents in a day. Now we do technology assisted review, where we'll create predictive models and concepts. Based on that, the machine will pick up 500 documents to be reviewed by humans. These are very unique documents about different topics, not related absolutely. Now, once these 500 documents are tagged into relevant, not relevant, into specific issue tags, priority list to be produced, we use that as a learning technique and apply that on the entire population again. The machine will again come up with 500 more documents that, these are ones again need to be reviewed. So you would only be manually reviewing 10% of the documents in a typical case, and not all the 60,000. Once those manual reviews been done, which is called the learning phase, we apply the entire review, which has been done manually through the machine using machine learning on the entire review population. And then the machine says, okay, everything is reviewed. A final QC is needed on certain documents, which the council will do, which is the level 2 review. And that's how you would reduce cost. And it's not just in India, it's happening everywhere. In fact, I think the US is more price sensitive on e-discovery than India is. So it's very, it's used very commonly now as a technique to reduce time and cost.
Thank you, Amit. In fact, this is the reason why e-discovery is preferred over physical discoveries, because you have techniques, you have blockchain, artificial intelligence and everything.
Yes.
So I'll take now last question. I'm conscious of that now we are running ahead of the time. Maybe in 30 seconds, starting from Dipti, if we can have the concluding remarks, what is the future of e-discovery?
I think the future is pretty bright as far as, the next few years are concerned. And I think everybody, the whole panel spoke about it, and the amount of information, data, expertise, everything, including, the chairman of MNLU, everybody is so conscious about this. I think we have a very bright future, and everybody is trying to, in their own way, trying to see how we can move forward in this direction by putting in their best practices. I think even the corporates are consciously aware of this fact.
Thank you. Kevin?
Yeah, I mean, e-discovery is the way forward, not just because corporates are storing most of their documents electronically. It is just an attempt by arbitration as an overall practice to figure out ways to streamline and make the discovery process more efficient. Institutions have to be nimble, making sure that they're keeping up, putting out guidelines, appointing tribunals that are acquainted with the e-discovery process, and generally staying ahead of the curve. This is actually a very good time for us because we've announced a revision to the SIC arbitration rules. So we'll be looking at all of virtual hearings, adapting perhaps our provisions on being able to order discovery. So it's a good opportunity for us right now.
Thank you. Mrinal?
I just have to add one point which Jayesh said earlier, that e-discovery, not just from the perspective of requesting on the counterparty, but there have been several instances and arbitration matters in which we have to analyze our clients' data over a period of last 10 years. And literally in one of the matters, my laptop crashed as soon as I had all the data. So I think it's maybe equally relevant to ask professionals and experts like Amit to come into assistance and analyze the data for our own clients, to run an e-discovery on our own client, so that A, we are fully prepared on our heads of claim strategy, on our dispute strategy. We are fully aware of what information we have on our side before we go to the case in front of the tribunal. That's all I have to say. Thank you.
Thank you. Amit?
I'd just like to say, I've been, this was a great session, and to see the participation here, which shows that the legal community in India is wholeheartedly, embracing e-discovery as an important aspect, and I've seen that very regularly in the Indian legal community. So with technology advances, with new media coming in, we are looking at virtual reality and augmented reality being adopted by companies post-COVID, in meetings, in conferences, making big decisions. So all of those data sources will also come into. I think the e-discovery space is going to continue to evolve, and I think that's the way to go, especially in arbitrations and investigations.
Maybe Jayesh, if we can have the final word.
Okay, thank you. First of all, thank you everybody for this wonderful session. If I were to sum up, I'll put it like this. One, it's here to say, stay and ignore at your peril. And two, a mindset change is required because, many people still operate from the physical world. And, I remember more than 15 years back at one of the international arbitration conferences attending the GC, saying like, when I'm asked, like, produce documents, okay, tell me what documents you will want and then produce accordingly. And obviously it was meant as a joke to make the point that those days are over. And in the electronic world, you try to hide something at your peril because the software and the ability to search is so strong, it will end up getting turned up. So all of this, of course, matters when we start seeing it getting applied. And that's the other reality, which is cross-border arbitrations, and Kevin will bear this out, like almost 30% of their arbitrations are from India. So cross-border arbitrations, this is a reality. Domestic arbitrations and courts in India, okay, we are at a very nascent stage, and that is something, that's why Dipti mentioned this point that, when the norms change here and this takes off, it will make a big difference to the cost. Cost will go down of, disputes resolution in India, and the time taken, because I may today deny I signed the document, I may deny XYZ and whatnot, but when that discovery is run on me and all of the internal communication turns up, I fall flat on my face. You have 2-3 spectacular such incidents, then the way defendants start conducting themselves will change dramatically, because they know that, I have to be mindful of what I say or what I don't say, because discovery will contradict me. That's it.
Thank you, Jayesh. Shubh, do you want to add up something?
No, I think
so.
I'm a lesser mortal in front of all these panelists. So
thank you so much, everyone, for sparing your time. To each one of you for sharing your valuable thoughts on the aspect of e-discovery. But I feel we need to see e-discovery in an integrated manner, especially in India, with e-courts, e-filing, and then virtual proceedings can be accompanied by the e-discovery, and that should be supported by the proper data protection regime. So thank you so much. I would like to thank our supporting partner, especially Mumbai Center for International Arbitration, who hosted this program. My thanks also go to Singapore International Arbitration Center, Juriscorp, Mahindra, and all the conversations what we were having were being live tweeted by the courtesy of SCC Online and EBC. I'm thankful to them also. Thank you so much for joining us.
Thank
Thank
you.
you. Have a great weekend.
Thank you, everyone. Stay safe. Bye.
Have a nice weekend.